Executive Summary, Convention of States. America is spiraling out of control. People who respect neither our institutions or our citizens are in control of the levers of power in Washington, D.C. They intend widespread destruction to the foundations of our republic. The bottom line is that Washington, D.C. today enjoys almost unchecked power. This is a systemic problem that requires a systemic solution. This is about more than elections. Elections cannot and will not solve the problems of a broken system. The only solution big enough to fix our nation's problems is a convention for proposing constitutional amendments to rein in federal tyranny. This is the people's final check on D.C., exercised through their state legislators, the ingenious plan of the founders to make state legislators' ambitions for state power counteract federal officials' ambitions for federal power, for the good of the people. While there is nothing wrong with the Constitution as drafted and ratified, the problems we now face are undeniably the result of improper constitutional interpretations by the federal courts, i.e. the General Welfare Clause, the Necessary and Proper Clause, and the Commerce Clause. Conservatives like to say that federal officials ignore the Constitution, but what they actually do is creatively lawyer around its limitations via Supreme Court rulings expanding federal power. We can and must restore the federal government to its proper limited place by pushing back on the expansion and effectively overturning bad Supreme Court precedents that have eviscerated the founders' intended limitations on our federal system. The Convention of States resolution seeks to do this by using the tool given to the states in Article 5 of the Constitution. It calls for an Article 5 convention limited to proposing amendments that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. How the process works. Article 5 of the Constitution provides two ways in which amendments may be proposed. Congress may propose them, or the states can call a convention of proposing amendments upon application of 2/3 of the state legislatures, or 34 state legislatures. Regardless of which way amendments are proposed, they must always be ratified by 3/4 of the states, or 38 states. The amendments that can be proposed must be germane to the resolution, limited by the language of the resolution itself, passed by the state legislatures as the subject matter of the convention. Only the proposed amendments that pass by a simple majority, 26 states, shall be put forth for ratification. They are mere suggestions until ratified. COS resolution language. The COS resolution's operative language defines the limits of the types of amendments that can be proposed. The operative language is as follows. Section 1. The legislature of the state of hereby applies to Congress under the provisions of Article 5 of the Constitution of the United States for the calling of a convention of the states limited to proposing amendments to the Constitution of the United States that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. Types of amendments that could be proposed. Limiting Supreme Court justices to 9 members of the court, preventing the federal government from adding states without the affirmative consent of 3/4 of the existing states, a limitation on using executive orders and federal regulations to enact laws, a balanced budget amendment, including limitations on taxes and spending, imposition of generally accepted accounting principles, or GAAP, single subject amendment, 1 subject per bill in Congress, a redefinition of the General Welfare Clause back to original intent. The original view was the federal government could not spend money on any topic within the jurisdiction of the states. A redefinition of the Commerce Clause back to original intent. The original view was that Congress was granted a narrow and exclusive power to regulate shipments across state lines, not all the economic activity of the nation. A prohibition of using international treaties and law to govern the domestic law of the United States. Placing an upper limit on federal taxation. Requiring the sunset of all existing federal taxes and a supermajority vote to replace them with new, fairer taxes. Religious Freedom Amendment, prohibiting the government from further interference with our religious freedoms. Regulatory curtailment by forcing Congress to vote on regulations instead of deferring lawmaking to regulators. Public opinion polling. Polling conducted across the nation indicates that, on average, 65.7% of voters across party lines support the Convention of States resolution. That includes 81.3% of Republicans, 50.2% of Democrats, and 63.3% of others. Polling was conducted by Robert Cahaley of the Trafalgar Group, America's most trusted and accurate pollster in the 2016, 2018, and 2020 elections. COS founders. Convention of States was founded by Mark Meckler, co-founder of Tea Party Patriots and president of Citizens for Self-Governance, and Michael Farris, founder of Homeschool Legal Defense Association, Patrick Henry College, and the former CEO of Alliance Defending Freedom. COS endorsers. Former U.S. Senator Rick Santorum now serves as senior advisor to Convention of States. Major endorsers include, but are not limited to, Mark Levin, Sean Hannity, Ben Shapiro, Governor Ron DeSantis, Representative Mark Meadows, Charlie Kirk, Pete Hegseth, Lieutenant Colonel Alan West, Dave Rubin, Representative Chip Roy, David Barton, James O'Keefe, Steve Dace, David Horowitz, Eric Metaxas, Dr. James Dobson, Representative Louis Gohmert, Senator Rand Paul, Senator Marco Rubio, Senator Jim DeMint, Governor Greg Abbott, the Honorable Jeb Bush, the Honorable Ben Carson, the Honorable Mike Huckabee, Governor Sarah Palin, Governor Bobby Jindal, Kenneth Cuccinelli, Representative Jeff Duncan, Representative Ralph Norman, Senator Jim Talent, and many more. The late U.S. Senator Tom Coburn was one of the leading proponents of COS and also served as a senior advisor. Conservative legal heavyweights serving on the Convention of States Legal Board of Reference include Mark Levin, Professor Robert P. George, Professor Randy Barnett, Ambassador C. Boyden Gray, Matt Staver, Andrew McCarthy, Dr. John Eastman, Charles Cooper, Professor Nelson Lund, Michael Farris, and Mark Meckler. Strategy for passage of the COS resolution. The strategy for passage of the resolution is state-specific and is carried out by the 5 million-plus citizen activists recruited from within 100% of the state legislative districts. Citizen activists put the appropriate pressure on their state representatives to sponsor or vote in support of the resolution. Learn more at conventionofstates.com. A solution as big as the problem. Michael P. Farris, Convention of States Action, Senior Fellow for Constitutional Studies. We see 4 major abuses perpetrated by the federal government. These abuses are not mere instances of bad policy. They are driving us towards an age of, quote, soft tyranny, unquote, in which the government does not shatter men's wills, but, quote, softens, bends, and guides them. If we do nothing to halt these abuses, we run the risk of becoming nothing more than, quote, a flock of timid and industrious animals of which the government is the shepherd, unquote. Alexis de Tocqueville, Democracy in America, 1840. Number 1. The spending and debt crisis. The national debt is staggering, but it only tells part of the story. Under standard accounting practices, the federal government owes trillions more in vested Social Security benefits and other programs. This is why the government cannot tax its way out of debt. Even if it confiscated everything, it would not cover the debt. Number 2, the regulatory crisis. The federal bureaucracy has placed a regulatory burden upon businesses that is complex, conflicted, and crushing. Little accountability exists when agencies, rather than Congress, enact the real substance of the law. Research from the American Enterprise Institute shows that since 1949, federal regulations have lowered the real GDP growth and have made America poorer. Number 3, congressional attacks on state sovereignty. For years, Congress has been using federal grants to keep the states under its control. Combining these grants with federal mandates, which are rarely fully funded, Congress has turned state legislatures into their regional agencies rather than respecting them as truly independent Republican governments. A radical social agenda and invasion of the rights of the people accompany all of this. While significant efforts have been made to combat this social erosion, these trends defy some of the most important principles. Number 4, federal takeover of the decision-making process. The founders believed that the structures of a limited government would provide the greatest protection of liberty. Not only were there to be checks and balances between the branches of the federal government, but power was to be shared between the states and federal government, with the latter only exercising those powers specifically granted in the Constitution. Collusion among decision makers in Washington, D.C. has replaced these checks and balances. The federal judiciary supports Congress and the White House in their ever-escalating attack upon the jurisdiction of the 50 states. We need to realize that the structure of decision-making matters. Who decides what the law shall be is as important as what is decided. The protection of liberty requires a strict adherence to the principle that power is limited and delegated. Washington, D.C. does not believe in this principle, as evidenced by an unbroken practice of expanding the boundaries of federal power. What does this mean? This is not a partisan issue. Washington, D.C. will never voluntarily relinquish meaningful power, no matter who is elected. The only rational conclusion is this: unless some political force outside of Washington, D.C. intervenes, the federal government will continue to bankrupt this nation, embezzle the legitimate authority of the states, and destroy the liberty of the people. Rather than securing the blessings of liberty for future generations, Washington, D.C. is on a path that will enslave our children and grandchildren to the debts of the past. The problem is big, but we have a solution. Article 5 gives us a tool to fix the mess in D.C. Our solution is big enough to solve the problem. Rather than calling a convention for a specific amendment, Convention of States Action urges state legislatures to properly use Article 5 to call a convention for a particular subject, reducing the power of Washington, D.C. It is important to note that a convention for an individual amendment would be limited to that single idea. Requiring a balanced budget is a great idea that COSA fully supports. Congress, however, could comply with a balanced budget amendment by simply raising taxes. We need spending restraints as well. We need restraints on taxation. We need prohibitions against improper federal regulation. We need to stop unfunded mandates. A convention of states needs to be called to ensure that we are able to debate and impose a complete package of restraints on the misuse of power by all branches of the federal government. What sorts of amendments could be passed? The following are examples of amendment topics that could be discussed at a convention of states: a balanced budget amendment, a redefinition of the General Welfare Clause. The original view was that the federal government could not spend money on any topic within the jurisdiction of the states. A redefinition of the Commerce Clause. The original view was that Congress was granted a narrow and exclusive power to regulate shipments across state lines, not all the economic activity of the nation. A prohibition on using international treaties and law to govern the domestic law of the United States. A limitation on using executive orders and federal regulations to enact laws, since Congress is supposed to be the exclusive agency to enact laws. Imposing term limits on Congress and the Supreme Court. Placing an upper limit on federal taxation. Requiring the sunset of all existing federal taxes and a supermajority vote to replace them with new, fairer taxes. Of course, these are merely examples of what would be up for discussion. The convention itself would determine which ideas deserve serious consideration, and it would take a majority of votes from the states to formally propose any amendments. The founders gave us a legitimate path to save our liberty by using our state governments to impose binding restraints on the federal government. We must use the power granted to the states in the Constitution. The Lamp of Experience: Constitutional Amendments Work. Written by Robert Nadelson, Independence Institute's Senior Fellow in Constitutional Jurisprudence and head of the Institute's Article 5 Information Center. Opponents of a convention of states long argued that there was an unacceptable risk that a convention might do too much. It now appears they were mistaken, so they increasingly argue that amendments cannot do enough. The gist of this argument is that amendments would accomplish nothing because federal officials would violate amendments as readily as they violate the original Constitution. Opponents will soon find their new position even less defensible than the old. This is because the contention that amendments are useless flatly contradicts over 2 centuries of American experience that demonstrates that amendments work. In fact, amendments have had a major impact on American political life, mostly for good. The framers inserted an amendment process into the Constitution to render the underlying system less fragile and more durable. They saw the amendment mechanism as a way to correct drafting errors, resolve constitutional disputes, such as by reversing bad Supreme Court decisions, respond to changed conditions, and correct and forestall government abuse. The framers turned out to be correct, because in the intervening years we have adopted amendments for all four of those reasons. Today, nearly all of these amendments are accepted by the overwhelming majority of Americans, and all but very few remain in full effect. Possibly because ratification of a constitutional amendment is a powerful expression of popular political will, amendments have proved more durable than some parts of the original Constitution. Following are some examples. Correcting drafting errors. Although the framers were very great people, they still were human, and they occasionally erred. Thus, they inserted into the Constitution qualifications for senators, representatives, and the president, but omitted any for vice president. They also adopted a presidential-vice presidential election procedure that, while initially plausible, proved unacceptable in practice. The founding generation proposed and ratified the 12th Amendment to correct those mistakes. The 25th Amendment addressed some other deficiencies in Article 2, which deals with the presidency. Both amendments are in full effect today. Resolving constitutional disputes and overruling the Supreme Court. The framers wrote most of the Constitution in clear language, but they knew that, as with any legal document, there would be differences of interpretation. The amendment process was a way of resolving interpretive disputes. The founding generation employed it for this purpose just 7 years after the Constitution came into effect. In Chisholm v. Georgia, the Supreme Court misinterpreted the wording of Article 3 defining the jurisdiction of the federal courts. The 11th Amendment reversed that decision. In 1857, the court issued Dred Scott v. Sanford, in which it erroneously interpreted the Constitution to deny citizenship to African Americans. The Citizenship Clause of the 14th Amendment reversed that case. In 1970, the court decided Oregon v. Mitchell, whose misinterpretation of the Constitution created a national election law mess. A year later, Americans cleaned up the mess by ratifying the 26th Amendment. All these amendments are in full effect today and fully respected by the courts. Responding to changed conditions. The 20th Amendment is the most obvious example of a response to changed conditions. Reflecting improvements in transportation since the founding, it moved the inauguration of Congress and President from March to the January following election. Similarly, the 19th Amendment, which assured women the vote in states not already granting it, was passed for reasons beyond simple fairness. During the 1800s, medical and technological advances made possible by a vigorous market economy improved the position of women immeasurably and rendered their political participation far more feasible. Without these changes, I doubt the 19th Amendment would have been adopted. Needless to say, the 19th and 20th Amendments are in full effect many years after they were ratified. Correcting and forestalling government abuse. Avoiding and correcting government abuse was a principal reason the Constitutional Convention unanimously inserted the state-driven convention procedure into Article 5. Our failure to use that procedure helps explain why the earlier constitutional barriers against federal overreaching seem a little ragged. Before looking at the problems, however, let's look at some successes. We adopted the 13th, 14th, 15th, and 24th Amendments to correct state abuses of power. All of these are in substantially full effect. In 1992, we ratified the 27th Amendment 203 years after James Madison first proposed it. It limits congressional pay raises, although some would say not enough. In 1951, we adopted the 22nd Amendment, limiting the president to 2 terms. It remains in full force, and few would contend it has not made a difference. Now, the problems. Because we have not used the convention process, the first 10 amendments, the Bill of Rights, remain almost the only amendments significantly limiting congressional overreaching. I suppose that if the founders had listened to the, quote, amendments won't make any difference crowd, they would not have adopted the Bill of Rights either. But I don't know anyone today who seriously claims the Bill of Rights has made no difference. Quote, I have but one lamp by which my feet are guided, and that is the lamp of experience, unquote, Patrick Henry said. Quote, I know of no way of judging of the future but by the past, unquote. In this case, the lamp of experience sheds light unmistakably bright and clear. Constitutional amendments work. The Article 5 Solution, Demystifying a Dusty Tool, written by Rita Peters, Esquire, National Legislative Strategist for Convention of States Action. Perhaps the most unifying conservative trait is the conviction that our founding fathers designed an ingenious federal system that we ought to conserve. But as federalism lies dying and our society spirals towards socialism, there is dissension among conservatives about using the procedure the founders left to the states to conserve it. Because Article 5's amendment-proposing convention process has never been used, some have branded it a mystical and dangerous power, a thing shrouded in mystery, riddled with unanswerable questions, and therefore best left alone. Some have literally labeled it a, quote, Pandora's box, unquote, the opening of which would unleash all manner of evil upon our beleaguered nation. Article 5 opponents accuse proponents of being reckless with the Constitution. They say we have no idea how a convention would work, who would choose the delegates, how votes would be apportioned, or whether the topic of amendments could be limited. My task today is to remove the shroud of mysticism by revealing what we do know about an Article 5 convention from its text, context, historical precedent, and simple logic. For starters, we know that the founders' whole purpose for including the convention mechanism was to provide a way for the states to bypass Congress in achieving needed constitutional amendments. An early draft of Article 5 vested Congress with the sole power to propose constitutional amendments. Under that version, 2/3 of the states could petition Congress to propose amendments, but it was still Congress that did the proposing. On September 15, 1787, George Mason strenuously objected to this, pointing out that such a system provided no recourse for the states if the national government should become tyrannical, as he predicted it would do. The result was the unanimous adoption of Article 5 in its current form, providing two ways for constitutional amendments to be proposed. Congress can propose them, or the states can propose amendments at a convention called by Congress upon application from 2/3 or 34 of the states. Regardless of which body proposes the amendments, proposals must be ratified by 3/4 or 38 of the states in order to become effective. We also know from history that voting at an Article 5 convention would be done on a one-state, one-vote basis. This is the universal precedent set by the 32 interstate conventions that occurred prior to the Constitution's drafting. It explains why it was unnecessary for Article 5 to specify the number of delegates to be sent by each state. The states can send as many delegates as they like, but each state only gets one vote. We know that state legislatures choose and instruct their convention delegates who act as agents of the state legislatures. Again, this is a matter of universal historical precedent for interstate conventions. On November 14, 1788, the Virginia General Assembly filed the very first application for an Article 5 convention to propose a Bill of Rights, aptly branding the convention, quote, a convention of the states, unquote, to be composed of, quote, deputies from the several states, unquote. Because Congress ultimately used its own Article 5 power to propose a Bill of Rights, that meeting was rendered unnecessary. But the application demonstrates the contemporaneous understanding that the convention process was state-led. The Supreme Court has likewise referred to the process as a, quote, convention of states, unquote. Finally, we know that the topic specified in the convention applications does matter. Over 400 applications for an Article 5 convention have been filed since the drafting of the Constitution. The reason we have never had one is because there have never been 34 applications seeking a convention for the same purpose. The state applications contain the agenda for an Article 5 convention, and until 34 states agree upon a convention agenda, there will be no convention. Because the authority of an Article 5 convention is derived from the 34 state applications that trigger it, the topic for amendments specified in those applications is a binding limitation on the scope of the convention. The unshrouded Article 5 convention isn't a Pandora's box at all, because there is no such thing as magic in a box for us to fear. There is only history, law, and reason to guide faithful Americans in tending their government. And precisely because there is no such thing as magic, we're going to need an effective tool to do the hard work of restoring our republic. It's time to dust off the tool the founders gave us in Article 5 and get started. 5 Myths About an Article 5 Convention, written by Rita Peters, Esquire, National Legislative Strategist for Convention of States. The constitutional boundaries separating the 3 federal branches and setting outer limits on their power are barely visible anymore. Many Americans are turning toward Article 5 of the Constitution to restore those boundaries. Constitutional amendment is strong medicine, to be sure, but it is the medicine that our founders prescribed for the disease of federal overreach that is otherwise terminal to our republic. Here are 5 myths about the Article 5 antidote and its side effects. Number 1. An Article 5 convention is a constitutional convention, or con-con. This point can get confusing because Article 5 is a provision of the Constitution, so a convention held pursuant to its terms could be described as, quote, constitutional, unquote, in that sense. But what most people mean when they describe an Article 5 convention as a con-con is that it is the same type of gathering as the one in 1787 that produced our Constitution, and that implication is clearly wrong. The distinction between the Philadelphia Convention of 1787 and a convention held pursuant to Article 5 lies in the source of authority for each. The states gathered in 1787 pursuant to their residual powers as individual sovereigns, not pursuant to any provision of the Articles of Confederation for proposing amendments. An Article 5 convention, on the other hand, derives its authority from the terms of Article 5 itself, and is therefore limited to proposing amendments to the Constitution we already have, pursuant to the prescribed procedures. Number 2. We have no idea how an Article 5 convention would operate. Article 5 itself is silent as to the procedural details of a convention, leading some to speculate that we are left clueless as to how the meeting would function. But while it's true that there has never been an Article 5 convention per se, the states have met in conventions an estimated 40 times. There is a clear precedent for how these meetings work. In fact, many of the framers had attended one or more conventions, and the basic procedures were always the same. For instance, voting at an interstate convention is always done as states, with each state getting 1 vote regardless of population or the number of delegates in attendance. That's why it's a convention of states, not a convention of delegates. The more detailed parliamentary rules of the convention are decided by the delegates at the convention itself. Number 3. The topic of an Article 5 convention cannot be limited, so convention delegates could rewrite the entire Constitution once they assemble. If states weren't free to define the scope of an Article 5 convention, then America would have already witnessed many of them. Over the course of our nation's history, states have filed over 400 applications for Article 5 conventions. The reason we haven't had one yet is because there have never been 34 applications requesting a convention on the same topic. Moreover, this proposition makes no sense from a historical, practical, or legal perspective. In every interstate convention ever held, there was always a specified topic or agenda for the meeting. Practically speaking, some limitation on the topic is necessary in order for the state legislatures to provide instructions to the delegates they send as their agents. States always instruct their delegates. Number 4. Congress would control an Article 5 convention. Anyone who has read James Madison's record of the Philadelphia Convention proceedings knows that the very reason the drafters added the convention method of proposing amendments to Article 5 was to give the states a way to bypass Congress, which has its own express power to unilaterally propose amendments. They would never have given Congress control over both methods. Congress only has 2 powers related to the convention: to issue the formal call, setting the date and location of the convention once 34 similar applications are received, and to choose between 2 methods of state ratification for any proposals offered by the convention. That's it. In fact, at least one federal court has definitively ruled that Congress cannot use any of its Article 1 powers, including its power under the Necessary and Proper Clause, to affect Article 5 procedures. Number 5. The Article 5 convention process has no safeguards to protect our Constitution from rogue delegates or big money special interest groups. To the contrary, the process is so well safeguarded that it has proven incredibly difficult to invoke. There are numerous redundant safeguards in the process. First, the topics specified in the 34 applications that trigger the convention act as an initial limitation on it. These applications are the very source of authority for the convention, so any proposals beyond their scope would be out of order. Second, state legislatures can recall any delegates who exceed their authority or instructions. Convention delegates are the agents of their state legislature and are subject to its instructions. As a matter of basic agency law, any actions taken outside the scope of a delegate's authority would be void. But the final and most effective protection of the process is the simple fact that it takes 38 states to ratify any amendment proposed by the convention. This means that it would only take 13 states to block any ill-conceived or illegitimately advocated proposal. Article 5's convention process is part of the beautiful constitutional machinery built to protect the states and the people from an overreaching federal government. It is time for us to use it. How we have learned more and more about the Constitution's, quote, Convention for Proposing Amendments, unquote. Written by Robert Nadelson, Independence Institute's Senior Fellow in Constitutional Jurisprudence and head of the Institute's Article 5 Information Center. You can classify modern Article 5 writing in 3 broad waves. There are many exceptions, but the generalization is valid, I think. The first wave consisted of publications from the 1960s and 1970s mostly, but not exclusively, by liberal academics who opposed conservative efforts to trigger a convention. Examples include articles by Yale's Charles Black, William and Mary's William Swindler, Duke's Walter Dellinger, and Harvard's Lawrence Tribe. Typically, these authors concluded that an Article 5, quote, constitutional convention, unquote, as they called it, could not be limited to a single subject. That, as we now know, was a mistake. A related error was their assumption that when the founders referred to a general convention, they meant a convention with unlimited subject matter. Actually, a general convention meant one in which all the states, or at least states from all regions, participated. It was the opposite of a partial or regional convention, and it had nothing to do with the scope of the subject matter. The mistakes these authors made can be attributed partly to the agenda-driven nature of their writings and their failure to examine many historical sources. They seldom ventured beyond the Federalist Papers and a few pages from the transcript of the 1787 Constitutional Convention. Also in the first wave was a 1973 study sponsored by the American Bar Association. The ABA document did conclude that a, quote, constitutional convention, unquote, could be limited, but it was not a very solid piece of research. Perhaps because, if my information is accurate, the principal writers were not professional scholars, but a pair of law students. The second wave began in 1979 with a publication issued by President Carter's U.S. Office of Legal Counsel and written by attorney John Harmon. For its time, it was a particularly thorough job. Among the other authors in this wave were Grover Rees III and the University of Minnesota's Michael Stokes Paulson. The most elaborate publication of this era was by Russell Kaplan, whose book, Constitutional Brinksmanship, was released by Oxford University Press in 1988. Second-wave authors assessed far more material than their predecessors. They paid more attention to the 1787 through 1790 ratification debates. Kaplan even made some reference to earlier interstate conventions. Most of them, Paulson was an exception, correctly concluded that an Article 5 gathering could be limited. But second-wave writers did make some mistakes. They continued to refer to an Article 5 conclave as a, quote, constitutional convention, unquote. Some of them assumed, as some first-wave writers had, that Congress had broad authority under the necessary and proper clause to regulate the convention and the selection and apportionment of delegates. None investigated the records of other interstate conventions in detail or fully grasped their significance. The third wave began in the 21st century. Its contributing authors include University of San Diego's Michael Rappaport, former House of Representatives Senior Counsel Mike Stern, Professor Roman J. Hoyos, Southwestern Law School, Los Angeles, John Malcolm, J.D. Harvard, Heritage Foundation, and myself, Robert G. Nadelson, Professor of Law, the University of Montana. Like most of the second-wave writers, we understand that an Article 5 convention can be limited, but we also have learned a lot of other things. The gathering is not a constitutional convention. It was modeled after a long tradition of limited-purpose gatherings, and it is governed by a rich history of practice and case law. We also know that the necessary and proper clause does not apply to conventions. That clause gives Congress power to make laws to carry into execution certain enumerated powers and, quote, all other powers vested by this Constitution in the government of the United States or in any department or officer thereof, unquote. But a convention for proposing amendments is not part of the, quote, government of the United States, unquote, nor is it a, quote, department or officer thereof, unquote. Supreme Court precedent, as well as the wording of the Constitution, make this clear. For this and other reasons, congressional powers over the process are quite limited. A few days ago, a friend sent me a 1987 report issued by the U.S. Justice Department. The title is, quote, Limited Constitutional Conventions under Article 5 of the United States Constitution, unquote. As the date would suggest, this is a typical second-wave publication. In addition to labeling an Article 5 convention as a, quote, constitutional convention, unquote, it also assumes that a general convention is one that is unlimited as to subject matter. It shows no familiarity with any previous interstate conventions other than the 1787 gathering. It makes the erroneous assumption that the latter meeting was called by Congress under the Articles of Confederation. It fails to understand the nature of the convention as a meeting of commissioners from state legislatures. It asserts erroneously that all 19th century state applications were for an unlimited convention. In fact, several were limited. And it makes the inaccurate assumption that Congress has power under the Necessary and Proper Clause to prescribe procedures for an amendments convention. Such documents are of historical interest, but they should no longer be taken as authoritative. The Necessary and Proper Clause does not empower Congress to control an amendments convention. Written by Robert Nadelson, Independence Institute's Senior Fellow in Constitutional Jurisprudence and head of the Institute's Article 5 Information Center. The framers inserted the, quote, convention for proposing amendments, unquote, in the Constitution to provide the states with a way of obtaining constitutional amendments without federal interference. Tench Cox, a leading advocate for the Constitution during the ratification debates, pointed out that the convention device allows the states to obtain whatever amendments they choose. Quote, although the President, Senate, and Federal House of Representatives should be unanimously opposed to each and all of them, unquote. The claim that Congress can use the Necessary and Proper Clause to structure the convention was first advanced in the 1960s and has been repeated numerous times since then. A Congressional Research Service report noted that some in Congress have taken the same line, although the report did not actually endorse it. But pause to consider, why would the framers place in the Constitution a method by which Congress could largely control a convention created to bypass Congress? Were the framers that stupid? Of course not. Most of them were highly experienced and extremely deft legal drafters. Behind the belief that the Necessary and Proper Clause empowers Congress to structure the convention are three distinct assumptions, all erroneous. They are, number one, that the scope of Congress's authority under the Necessary and Proper Clause is broader than it is. Number two, that the clause covers the amendment process. And number three, that ordinary legislation may govern the amendment process. The Necessary and Proper Clause is the last item in the Article 1, Section 8 list of congressional powers. It reads, quote, the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof, unquote. It happens that the most extensive treatment of the Necessary and Proper Clause is an academic book I co-authored with Professors Gary Lawson, Guy Seidman, and Jeff Miller, The Origins of the Necessary and Proper Clause, Cambridge University Press, 2010, cited by Justice Thomas in a Supreme Court case in 2014 and apparently relied on by Chief Justice Roberts in 2012. This book reveals the Necessary and Proper Clause to be a masterpiece of legal draftsmanship. The clause was based on usage common in 18th century legal documents. It is not a grant of authority, but a rule of interpretation. It tells us to construe certain enumerated powers as the ratifiers understood them, rather than in an overly narrow way. In legal terms, the necessary and proper clause informs us that those enumerated powers include, quote, incidental, unquote, authority. Even if the clause did apply to the amendment process, the authority, quote, incidental, unquote, to Congress's call would be quite narrow. An entity that calls an interstate convention always has been limited to specifying the time, place, and subject matter. It is the state legislatures that control selection of their own commissioners. But in fact, the necessary and proper clause does not extend to the amendment process. To explain, the Constitution includes numerous grants of power. These grants are made to Congress, to the President, to the courts, to the Electoral College, and to state legislatures, state governors, and various conventions. An entity exercising a power under one of those grants is said to exercise a, quote, federal function, unquote. The necessary and proper clause is crafted to apply to most federal functions, but it also excludes a number of them. Specifically, it covers only the grants listed in Article 1, Section 8, and those vested in the, quote, government of the United States, unquote, and in, quote, departments, unquote, and, quote, officers, unquote, of that government. In other words, the clause omits constitutional grants made to entities that are not part of the, quote, government of the United States, unquote, even when those entities exercise, quote, federal functions, unquote. See, for example, Ray versus Blair, 343 U.S. 214, holding that presidential electors who ultimately derive their power from the Constitution exercise a federal function but are not federal officers or agents. The convention for proposing amendments is one of a handful of entities that falls into this category. Even if we did assume, for sake of argument, that Congress is a, quote, department, unquote, of the federal government for other purposes, the rules for Article 5 are different. The difference is that, according to the courts, when Congress and state legislatures act in the amendment process, they do not act as the legislative branches of their respective governments. Instead, they act as ad hoc assemblies for registering the popular will. They can exercise only the power granted by Article 5 and not powers granted by other parts of the U.S. Constitution or by state constitutions. Thus, in Idaho versus Freeman, a federal court ruled that, quote, Congress, outside the authority granted by Article 5, has no power to act with regard to an amendment, i.e., it does not retain any of its traditional authority vested in it by Article 1, unquote, which includes the necessary and proper clause. This case was later vacated as moot, but there were no problems with the merits of the ruling. Or, as the Supreme Court of Missouri pointed out when addressing the state legislature's Article 5 functions, quote, the legislature was not, strictly speaking, performing the functions of a legislative body for the state, but was acting as a representative of the people, pursuant to authority delegated to it by the federal Constitution, unquote. The U.S. Supreme Court denied certiorari in that case, meaning it refused to consider reversing this decision. Again, when legislatures act under Article 5, they do so as separate assemblies, not as the legislative branches of their governments. This is a very old principle dating back to 1798, when the Supreme Court held that congressional amendment proposals do not need presidential signature. See also United States versus Sprague, 1931. Well, if Congress cannot insert language in the, quote, call, unquote, structuring the convention, can it pass laws for the same purpose? Again, the answer is no. A long list of 20th century cases from courts at all levels holds that the amendment process is governed by the express and implied provisions of Article 5, not by other sources of law such as statutes, state constitutions, or ordinary legislative rules. See, for example, Lesser v. Garnett and Dyer v. Blair. The Myth of a Runaway Amendments Convention, written by Robert Nadelson, Independence Institute's Senior Fellow in Constitutional Jurisprudence and head of the Institute's Article 5 Information Center. The founders bequeathed to Americans a method to bypass the federal government and amend the Constitution, empowering 2/3 of the states to call an amendments convention. In the wake of Mark Levin's best-selling book, The Liberty Amendments, proposing just such a convention, some have raised entirely unnecessary alarms. But their concerns are based on an incomplete reading of history and judicial case law. Those speculations simply overlook the last 3 decades of research into the background and subsequent history of the Constitution's amendment process. They also ignore how that process actually works and how the courts elucidate it. Article 5 of the Constitution provides for a, quote, convention for proposing amendments, unquote. The founders inserted this provision to enable the people acting through their state legislatures to rein in an abusive or runaway federal government. In other words, the founders created the convention for precisely the kind of situation we face now. There is a great deal we know about the subject. The, quote, convention for proposing amendments, unquote, was consciously modeled on federal conventions held during the century leading up to the Constitutional Convention. During this period, the states, and before independence, the colonies, met together on average about every 40 months. These were meetings of separate governments, and their protocols were based on international practice. Those protocols were well established and are inherent in Article 5. Each federal convention has been called to address one or more discrete prescribed problems. A convention call cannot determine how many delegates, or commissioners, each state sends or how they are chosen. That is a matter for each state legislature to decide. A convention for proposing amendments is a meeting of sovereignties or semi-sovereignties, and each state has one vote. Each state commissioner is empowered and instructed by his or her state legislature or its designee. As was true of earlier interstate gatherings, the Convention for Proposing Amendments is called to propose solutions to discrete pre-assigned problems. There is no record of any federal convention significantly exceeding its pre-assigned mandate, not even the Constitutional Convention, despite erroneous claims to the contrary. The state legislature's applications fix the subject matter for a convention for proposing amendments. When 2/3 of the states apply on a given subject, Congress must call the convention. However, the congressional call is limited to the time and place of meeting and to reciting the state-determined subject. In the unlikely event that the convention strays from its prescribed agenda and the commissioners escape recall, any proposal they issue is ultra vires, beyond powers, and void. Congress may not choose a, quote, mode of ratification, unquote, for that proposal, and the necessary 3/4 of the states would not ratify it in any event. The courts can and do adjudicate Article 5 cases. There has been a long line of those cases from 1798 into the 21st century. But, you might ask, will the prescribed convention procedures actually work? They already have. In 1861, in an effort to prevent the Civil War, the Virginia legislature called for an interstate gathering formally entitled the Washington Conference Convention, and informally, the Washington Peace Conference. The idea was that the convention would draft and propose one or more constitutional amendments that, if ratified, would weaken extremists in both the North and the South, and thereby save the Union. This gathering differed from an Article 5 convention primarily in that it made its proposal to Congress rather than to the states. In virtually every other respect, however, it was a blueprint for an Article 5 convention. When the convention met in Washington, D.C. on February 4, 1861, 7 states already had seceded. Of the 26 then remaining in the Union, 21 sent committees, delegations. The conference lasted until February 27th, when it proposed a 7-section constitutional amendment. The Assembly followed to the letter the convention rules established during the 18th century, the same rules relied on by the Constitution's framers when they provided for a convention for proposing amendments. Specifically, the convention call fixed the place, time, and topic, but did not try to dictate other matters, such as selection of commissioners or delegates or convention rules. At the convention, voting was by state. One vote was apparently inadvertently taken per capita, but that was quickly corrected. The committee from each state was selected in the manner that state's legislature directed. The conclave adopted its own rules and selected its own officers. Former President John Tyler served as president. The commissioners stayed on topic. One commissioner made a motion that was arguably off topic, changing the president's term of office, but that was voted down without debate. Congress subsequently deadlocked over the amendment, but the convention itself did everything right. Although the convention met in a time of enormous stress, this dry run came off well. In any political procedure, there are always uncertainties, but in this case, they are far fewer than predicted by anti-convention alarmists, and they must be balanced against a certainty. Unless we use the procedure the founders gave us to rein in a runaway Congress, then Congress will surely continue to run away. The Article 5 Solution and the Absurdity of Inaction. Written by Rita Peters, Esquire, National Legislative Strategist for Convention of States Action. Far and away, fear is the most common rationale among opponents of Article 5's convention process for proposing constitutional amendments. Fear of the uncertain result, fear of a congressional takeover, fear of George Soros and what his money might buy. But even as naysayers sit in their meeting rooms and chat rooms opining about hypothetical rogue delegates to a hypothetical convention, Congress continues to spend money that our great-grandchildren will one day owe. Our president continues to use creative legal arguments to erase the lines that once separated constitutional powers, thrusting himself into the business of lawmaking. Unelected bureaucrats continue to churn out mountains of regulations that are unauthorized by Congress and in some cases put hardworking Americans out of work. And the Supreme Court is near to a revocation through interpretation of our right to bear arms. Rather than checking and balancing one another as they were designed and empowered to do, the three branches of the federal government are acting in concert to further concentrate their power at the expense of state prerogatives and individual liberty. All three branches are effectively making laws. Congress, the intended lawmaking branch, has extended its lawmaking into matters reserved to the states, and our unaccountable Supreme Court finds inventive ways to interpret the Constitution so as to justify this, not because it can't determine the Constitution's original meaning, but because the original meaning doesn't matter if our Constitution is, as we are told, quote, a living, breathing document, unquote. Meanwhile, administrative agencies, the bold and unmanageable fourth branch of government, have broken the will of the American people by the sheer volume of their regulations, rules, and reports. The Environmental Protection Agency's 376-page, quote, regulatory impact analysis, unquote, for its war on coal begins with a 5-page list of acronyms to be learned by the aspiring reader, a virtual electric fence to all but the most intrepid citizen. How can we be a self-governing people when we are completely removed from the invisible hands that actually regulate us, with no means of holding them accountable and no hope of knowing or understanding the laws they are making? Many who oppose using Article 5's convention process would agree that well-designed constitutional amendments could close court-created structural loopholes that have damaged our federal structure and concentrated power in Washington, D.C. For instance, we could require congressional approval for all administrative regulations. We could clarify where Congress's authority ends and the state's authority begins so that Congress could actually have time to do its constitutional job. Yet some insist that an amendment proposing convention amounts to open-heart surgery for our Constitution, and that nothing could ever justify such an action. An admittedly imperfect but well-prepared team of doctors is standing by, eager to stop the bleeding and close up the wound. But a fearful crowd of skeptics is blocking the way. They love this patient and are not entirely convinced that the doctor's training is sufficient. Do they have the proper supplies? What if armed gunmen enter the surgical ward and interrupt the life-saving process? No, the skeptics conclude, we can't be assured of a good outcome, so we had better just stand by. And the patient's life ebbs away. We could learn a lot from Dietrich Bonhoeffer, the German pastor who resolved to actively resist Adolf Hitler at any cost. Bonhoeffer had a painful understanding that it is our actions, not our sentiments, that reveal our truest convictions, and that our desire for safety can be an obstacle to the action that our professed morality requires. In 1934, he explained, quote, "There is no way to peace along the way of safety, for peace must be dared. It is itself the great venture and can never be safe. Peace is the opposite of security," unquote. It was also Bonhoeffer who said, quote, "Not to act is to act," unquote. The Founding Fathers gave us a tool in Article 5 to restrain federal power through state-proposed constitutional amendments. I do not doubt that the conservatives trying to block the use of this tool have sincere reverence for our founding document, but mere sentiments cannot rescue our Constitution from continued disfiguration under the federal scalpel, nor close the wounds that are standing open, even as we continue this debate. Can we trust the Constitution? Answering the runaway convention myth, written by Michael Ferris, J.D., and LLM. Some conservatives contend that our Constitution was illegally adopted as the result of a, quote, runaway convention, unquote. They make two claims. Number one, the delegates were instructed to merely amend the Articles of Confederation, but they wrote a whole new document. And number two, the ratification process was improperly changed from 13 state legislatures to 9 state ratification conventions. The claim that the delegates disobeyed their instructions is premised on the idea that Congress called the Constitutional Convention. It is claimed that Congress instructed the delegates to solely amend the Articles of Confederation. A review of legislative history clearly reveals the error of this claim. The Annapolis Convention was the political impetus for calling the Constitutional Convention. The conclusion of the commissioners from the 5 participating states was that a broader convention should be called. They named the time and date, Philadelphia, second Monday in May. But who was to call the convention? They said they were going to work to, quote, procure the concurrence of the other states in the appointment of commissioners, unquote. The goal of the upcoming convention was, quote, to render the Constitution of the federal government adequate for the exigencies of the Union, unquote. What role was Congress to play in calling the convention? None. The Annapolis delegates merely sent a copy of their resolution to Congress and the executives of all states, quote, from motives of respect, unquote. What authority did the Articles of Confederation give to Congress to call such a convention? None. The power of Congress under the Articles was strictly limited, and there was no theory of implied powers. The states possessed residual sovereignty, which included the power to call this convention. 7 state legislatures agreed to send delegates to the convention in Philadelphia prior to the time that Congress acted to endorse the convention. The states told their delegates that the purpose of the convention was the one stated in the Annapolis Convention resolution, quote, to render the Constitution of the federal government adequate for the exigencies of the Union, unquote. Congress voted to endorse this convention on February 21, 1787. It did not purport to, quote, call, unquote, the convention or give instructions to the delegates. It merely proclaimed that, quote, in the opinion of Congress, it is expedient, unquote, for the convention to be held in Philadelphia on the date previously informally sanctioned by the Annapolis Convention and formally approved by 7 state legislatures. Ultimately, 12 states appointed delegates. 10 of these states followed the phrasing of the Annapolis Convention with only minor variations in wording, quote, render the federal Constitution adequate, unquote. 2 states, New York and Massachusetts, followed the formula stated by Congress, quote, solely amend the articles, unquote, as well as, quote, render the federal Constitution adequate, unquote. But every student of history should know that the instructions for delegates came from the states. In Federalist 40, James Madison answered the question of, quote, who gave the binding instructions to the delegates, unquote. He said, quote, the powers of the convention ought, in strictness, to be determined by an inspection of the commissions given to the members by their respective constituents, unquote. He then spends the balance of Federalist 40 proving the delegates from all 12 states properly followed the directions they were given by each of their states. He specifically calls the February 21st resolution from Congress, quote, a recommendatory act, unquote. The states, not Congress, called the Constitutional Convention. They told their delegates to render the federal Constitution adequate for the exigencies of the Union, and that is exactly what they did. The Articles of Confederation called for approval of any amendments by Congress and ratification by Annapolis Convention document, and a clear majority of states stated that any amendments coming from the Constitutional Convention would have to be approved in this same manner by Congress and all 13 state legislatures. The reason for this rule can be found in the principles of international law. The states were sovereigns. The Articles of Confederation were, in essence, a treaty between 13 sovereign states. Normally, the only way changes in a treaty can be ratified is by the approval of all parties to the treaty. However, a treaty can provide for something less than unanimous approval if all the parties agree to a new ratification process before the change in process is effectual. When the convention sent its draft of the Constitution to Congress, it also sent a recommendation for a new ratification process. Congress approved both the Constitution itself and the new process. Along with changing the number of required states from 13 to 9, the new ratification process stated that state conventions would ratify the Constitution rather than the legislatures. This was done in accord with the preamble of the Constitution. The supreme law of the land would be ratified in the name of, quote, "we the people," unquote, rather than, quote, "we the states," unquote. But before this change in ratification could be valid, all 13 state legislatures would have to consent to the new method. All 13 state legislatures consented to the new ratification process by calling conventions of the people to vote on the merits of the Constitution. 12 states held popular elections to vote for delegates. Rhode Island made every voter a delegate and held a series of town meetings to vote on the Constitution. Every state legislature consented to the new process that was aimed at obtaining the consent of the people themselves. Those who claimed to be constitutionalists while contending that the Constitution was illegally adopted are self-conflicted. It is like saying George Washington was a great American hero, but he was also a British spy. I stand with the integrity of the Constitution. In July 2015, Professor Rob Natelson, one of the nation's leading Article 5 experts, crafted an initial draft of rules for a Convention of the States, along with Convention of States Project co-founder Michael Ferris. Since then, a group of 200-plus state legislatures from 40 states have been invited to review Natelson's rules and provide input. A version of these rules were successfully utilized at the 2016 and 2023 simulated Article 5 conventions, hosted by Convention of States Foundation. Convention for Proposing Amendments. Proposed Rules. Rule 1. Questions not governed by these rules shall be governed by the latest published edition of Mason's Manual of Legislative Procedure, except where the rule in that manual can be applied only to a state legislature rather than a convention, in which case the matter shall be determined by parliamentary common law. Rule 2. Officers. Section A. The officers of the convention shall consist of a president and vice presidents, who shall be elected from among the commissioners, and the following, who shall be elected from among persons not commissioners: secretary, sergeant-at-arms, parliamentarian, and assistant parliamentarian. All officers shall be on oath to carry out their duties faithfully and in accordance with lawful conduct. Section B. The temporary convention president shall be appointed from among the commissioners from the state that was the first to enact the application that led to the calling of this convention. The temporary president shall be selected by a majority vote of that state's delegation. The temporary president's sole duty shall be to preside over the election of the convention president, and he or she shall be ineligible to be the permanent president. Rule number 3. The sergeant-at-arms is empowered, under direction of the President, to secure the good order of the House. Orders issued by the President to the sergeant-at-arms shall be appealable, as in the case of other rulings of the Chair. Rule number 4. The members of this convention are the committees, delegations, appointed by their respective states. All votes shall be taken by states, with each state having one vote. In roll call votes, states shall declare their votes in alphabetical order. Rule number 5. Irrespective of how many commissioners a state includes within its delegation, no more than 5 commissioners from any one state shall be on the floor at the same time. Rule number 6. A quorum to do business shall consist of the commissioners empowered to cast the votes of not less than 26 member states, and all questions shall be decided by the greater number of those which be fully represented, but a lower number than 26 may adjourn from day to day. Rule number 7. The order of business shall be as follows. Number 1, call to order. Number 2, roll call. Number 3, invocation. Number 4, pledge of allegiance. Number 5, reading and approval by the clerk of the minutes of the previous day. Number 6, reports of standing committees. Number 7, reports of special or select committees. Number 8, special orders. Number 9, unfinished business. Number 10, introduction and first reading of proposals. Number 11, consideration of daily calendar. Number 12, announcement of committee meetings. And number 13, recess for the day, adjournment. Rule number 8. Every commissioner rising to speak shall address the President, and while he or she shall be speaking, no one shall pass between them or read any written matter not immediately germane to the question under consideration. Rule number 9. Of 2 commissioners rising to speak at the same time, the President shall name the one who shall first be heard. Rule number 10. A commissioner shall not speak oftener than twice, without special leave upon the same question, and not a second time before every other who had been silent but shall choose to speak on the subject shall have been heard. The commissioners from any one state committee shall not speak oftener than 10 times without special leave upon the same question, and not more than 5 times before every other who had been silent but shall choose to speak on the subject shall have been heard. Rule 11. No commissioner shall, without leave of the convention, speak more than 10 minutes at any one time. Rule number 12. A motion made and seconded shall be repeated, and if written, as it shall be when any member shall so require, shall be read aloud by the secretary or transmitted to each commissioner's pre-designated electronic device before it shall be debated. No motion, other than a procedural motion, shall be in order unless germane to both the subject matter specified in the state applications on which Congress called the convention and to the subject matter specified in the convention call. Rule 13. A motion may be withdrawn at any time before the vote upon it shall have been declared. Rule number 14. When a debate shall arise upon a question, no motion other than to amend the question, to commit it, or to postpone the debate shall be received. Rule number 15. A question that consists of one or more propositions shall, at the request of any commissioner, be divided and put separately as to each proposition. Rule number 16. No substantive question or committee recommendation shall be decided the day on which it is introduced or first debated if any 5 states request that the decision be postponed to another day. Rule number 17. A motion to reconsider a matter that has been determined by a majority may be made with leave unanimously given on the same day on which the vote passed, but otherwise not without 1 day's previous notice, in which last case, if the House agree to the reconsideration, the convention, or, by the convention's leave, the President shall assign a future day for the purpose. Rule number 18. A commissioner may be called to order by another commissioner, as well as by the President, and may be allowed to explain his or her conduct or any expressions supposed to be reprehensible. Rule 19. All questions of order shall be decided by the President, subject to appeal to the House, but without debate. Rule number 20. Upon a question to recess for the day, which may be made at any time, if it be seconded, the question shall be put without debate. Rule 21. When the convention shall recess, every commissioner shall stand in his or her place until the President pass. Rule 22. No commissioner shall be absent from the convention so as to interrupt the representation of his or her state without leave. Rule 23. Committees. Generally applicable provisions. Number 1. The standing committees shall include rules, credentials, administration, fiscal restraints, federal jurisdiction, and term limits. The convention may create ad hoc committees. Number 2. The membership of the rules, credentials, and administration committees shall be elected by a plurality vote of the states, voting by secret ballot. The membership of ad hoc committees shall be appointed by the President unless the convention shall prescribe another method. The membership of the fiscal restraints, federal jurisdiction, and term limits committees shall be selected by the method designated in Rule 24. Number 3. Each committee may, by majority vote, create subcommittees for issues germane to the committee's assigned task. Number 4. Committees and subcommittees shall not sit while the convention shall be or ought to be sitting without leave of the convention. Rule number 24. Fiscal restraints, federal jurisdiction, and term limits committees. Number 1. The Fiscal Restraints Committee, Federal Jurisdiction Committee, and Term Limits Committee each has exclusive responsibility for developing proposals within the corresponding subject matter of the state applications for the convention. Number 2. Each of these 3 committees shall consist of 1 member from each state delegation, selected as determined by such delegation, provided, however, that no person shall serve on more than one of those 3 committees. Number 3. Any proposal approved by a subcommittee of any of these 3 committees shall be referred to its committee chairman, who shall schedule it for hearing within 5 days of its referral from the subcommittee. The committee shall vote on any proposal endorsed by at least 5 committee members within 24 hours after the hearing, weekends and holidays excluded. Approval shall be by a simple majority of committee members present and voting. Number 4, every proposal reported from the Fiscal Restraints, Federal Jurisdiction, or Term Limits Committee shall be scheduled for debate and a vote on the floor of the convention. The presiding officer of the convention shall have no authority to refuse to schedule debate or a vote on any such proposal, and no formal rule shall be required to schedule any such proposal for debate or a vote. No motion to adjourn sine die shall be in order so long as any such proposal remains without a convention vote to pass, reject, or table. America's Soul Sickness, written by Rita Peters, Senior Vice President for Legislative Affairs with Convention of States Action. This time of year finds me watching plenty of committee hearings and floor debates in state legislatures across the nation. And while I see glimpses of passion, statesmanship, and standing on principle, I also see discouraging symptoms of a political epidemic that seems to afflict conservatives in particular. It's the conviction that our national doom is inevitable and that no one can be trusted to act wisely or in the nation's best interest. It's the attitude of hunker down and defend, instead of moving forward to improve. In short, it's bunker politics. On the other hand, Convention of States Action is working to implement a meaningful solution to the problems that ail our federal system. We aim to bring about the nation's first convention for proposing amendments. It's a process gifted to the state legislatures in Article 5 of the Constitution. It gives the states the same power to propose amendments as Congress has, because the founders knew that the states might need that kind of check if the federal government started to overstep its bounds. Using this process, the states can reverse bad Supreme Court precedents and put Congress back in its box. They can force Congress to stop its reckless spending. They can end the federal stranglehold on education, the environment, and small business. The process is a meeting of the states through their own chosen delegations to propose amendments on the limited agenda agreed to in advance by 34 states, imposing fiscal restraint, limiting federal power and jurisdiction, and setting term limits for federal officials. But those who deal in bunker politics can't stomach the idea that there is actually something we can do to repair our broken federal structure. So instead of putting their energy into the common sense solution contained in our Constitution, they put their energy into stopping it. The John Birch Society, a leading practitioner of bunker politics, doesn't seem to mind that its bedfellows are groups who actually want a bigger federal government. So they stand with Common Cause, the League of Women Voters, Planned Parenthood, and the Sierra Club to say, stop, this is scary. They make outlandish predictions about the repeal of the Second Amendment, not possible legally or politically. They accuse our founding fathers of being scoundrels who abused the public trust in crafting our current Constitution. Completely false. They say we don't know how an Article 5 convention would work. Utterly untrue. They claim to love the Constitution so much that they abhor the idea of amending it. Never mind that through amendments we have protected freedom of religious exercise, abolished slavery, and given women the right to vote. Never mind that the very process they so vehemently opposed is part of our beloved Constitution. They deal in emotion rather than reason. The practical result of bunker politics is paralysis. When we see monsters under the bed and attackers around every corner, we can't make any significant progress toward a more just and virtuous society. No one is winsome or persuasive when they're ruled by fear and suspicion. At the end of the day, bunker politicians end up in the pathetic position of defending the status quo they don't want. They complain about the national debt. They bemoan federal control of virtually all public policy, but they won't use the one constitutional tool given to them to actually fix the problem. The good news is our founding fathers anticipated all of this because they knew the natural tendencies of mankind. So they gave us a constitutional system fitted with all the processes needed to keep it healthy. If we choose to cower in fear and turn our backs on one of those processes, we shouldn't be surprised to be stuck in this mess. Americans who have the courage to keep working toward reform, to engage instead of retreat, need to step up. Bunker politics has no place among a self-governing people, and it is unbecoming of any public official who would deign to lead us.